If a loved one is incompetent and they face an immediate risk to their money, their property, or their person, what do? Hi, I'm Brenton Begley, attorney and partner with McIntyre Elder Law. Today I want to talk about emergency guardianships. So guardianships is a process that you go through to have somebody adjudicated incompetent and another person appointed to make decisions on their behalf. Now, the reason why this may happen is if you have a loved one, for example, who has Alzheimer's dementia, maybe they've had a stroke, and they've been managing their own money, managing their own finances, but something happens to them where they can no longer do that. They're incompetent, incapacitated, or otherwise unable to act for some type of, underlying, debilitating condition. So if that is the case and nobody has been appointed power of attorney, or maybe there was a power of attorney in place and it named somebody who passed away or named somebody who's just not available to act, then what is the alternative? Well, the alternative would be to seek guardianship of that person. So a loved one or the state can petition the court to have a guardian appointed for that individual. Now, if that individual faces an immediate threat to their money, their property, or their person, meaning they're not going to be able to pay their bills and they have bills upcoming, meaning they're about to face large costs for long-term care, tens of thousands of dollars worth of fees for long-term care, and nobody can access their money to pay for that care, meaning if they don't have somebody appointed for them to place them in a facility, they can't live alone. They need someone to take care of them or place them in a facility to get the proper level of care. If these conditions are met, you can seek what's called emergency guardianship, also known as a motion for an interim guardian. Now, an interim guardian is somebody who is appointed as guardian for the interim, right? So what that means is that there's been a petition for guardianship filed with the court, okay? And that petition ultimately seeks to have an individual adjudicated incompetent and another person appointed to make their decisions. But in the meantime, between when you file the petition and when you have the ultimate hearing on guardianship, that could be weeks, that could be months. So in the meantime, if there is an imminent and foreseeable risk to that individual, you can ask the court to appoint somebody in the interim. Now, to prove that somebody is incompetent such that they are adjudicated incompetent, you have to prove by clear, convincing, and cogent evidence to the court that that individual is incompetent. So in an emergency situation, it is, a lower bar because it's an emergency. So you have to show to the court that it's more likely than not that the person's incompetent. And it's more likely than not that if a guardian is not appointed for the interim, that they will face the risk of, to their money, to their property, to their person. Okay, so if you're in a position where you have a loved one that is incompetent, incapacitated, and doesn't have a power of attorney and needs a guardian, then we're happy to help, okay? But you should think about whether or not you should move for an interim guardian because you don't want to be waiting for the court to do their thing, for the process to go through, and leave that person in a situation where they face unnecessary risk. If you have questions about guardianship and how to navigate it, you can give us a call, 704-259-7040, or visit our website, mcelderlaw.com.